Maurice McLoughlin is an Australian businessman. He is also a philanthropist. He travels to the Philippines to help the poor children and give gifts to charities. He was staying at Sheraton Hotel during his trips to the Philippines. Brunhilde Tan met Maurice McLoughlin, and eventually, Maurice was convinced by Brunhilde to stay at Tropicana Hotel. On October 30, 1987, Maurice rented a safety deposit box owned by Tropicana. The safety deposit box could only be opened through the use of two keys. One is given to the registered guest, and the other remaining in the possession of the management of the hotel. When a registered guest wished to open his safety deposit box, he alone could personally request the management. The management will assign one of its employees to accompany the guest and assist him in opening the safety deposit box with the two keys. Maurice claims that he had placed cash, letters, credit cards, bank books, and a checkbook inside the safety deposit box. Fast forwarding the events, the money that Maurice placed in the deposit box were partially lost. It was then later found that Brunhilde Tan, together with the hotel manager, and the employee in custody of the safety deposit box were the ones who stole from the safety deposit box rented by Maurice. Maurice wants the hotel to be responsible for the loss. However, the hotel manager argued that the hotel is not responsible based on the conditions for renting the safety deposit box. One of the conditions states that the hotel shall be free from any liability if there is any loss in the contents. Maurice's lawyers advised him that such condition is void because it violates the universal hotel practices and customs. Maurice filed a suit for damages against the defendants. The RTC ruled in favor of Maurice, which was supported by the CA. The issue now, as stated in the beginning of the decision, is that whether the hotel may escape liability if the items left with it for safekeeping by its guests are lost. Can the hotel escape liability by asking its guests to sign a waiver saying that the hotel, together with its employees, will not be held liable for the loss of the items? The Supreme Court ruled in favor of Maurice. The Supreme Court held that such kind of waiver, that the hotel shall be free from any liability if there is any loss in the contents of the rented safety deposit box, is null and void. Article 2003 of the new Civil Code states that the hotel keeper cannot free himself from responsibility by posting notices to the effect that he is not liable for the articles brought by the guest. Any stipulation between the hotel keeper and the guest, whereby the responsibility of the hotel keeper is defeated or diminished, shall be void. The responsibilities of the hotel keeper are laid out in the new Civil Code, specifically in Articles 1998 to 2001. The hotel business, like the common carrier's business, is imbued with public interest. Catering to the public, hotel keepers are bound to provide not only lodging for hotel guests, but also security to their persons and belongings. The law does not allow such duty to be diminished by any agreement between the parties. It is not even necessary that the things be actually delivered to the innkeepers or their employees. It is enough that such things are within the hotel or inn. Hence, it is with greater reason that the liability of the hotel be enforced when the missing items are taken without the guest's knowledge and consent from a safety deposit box provided by the hotel. In this case, the waiver signed by Maurice is null and void. The waiver violates Article 2003 of the new Civil Code because it allows Tropicana to be released from liability arising from any loss in the contents of the safety deposit box. Evidently, the undertaking was intended to bar any claim against Tropicana for any loss of the contents of the safety deposit box, whether or not negligence was incurred by Tropicana or its employees. It is the loss through force majeure that may spare the hotel keeper from liability. Also, a depositary is not responsible for the loss of goods by theft, unless his actionable negligence contributes to the loss. Tropicana argued, saying that this case is based on contract and that the lower courts granted the claims of Maurice based on tort. The Supreme Court found nothing wrong with that. An important note to remember is that tort liability can exist even if there are already contractual relations. The act that breaks the contract may also be tort. Thank you for watching. Subscribe and share for more digest like this.